Well, good morning or good afternoon, everyone, all of you who are joining the webinar today. And it's my pleasure to welcome you all to the launch of a new Bonavero report entitled From Litigation to Implementation, Framing Smart Remedies in Rights-Based Climate Litigation. My name is Başak Çalı, and I'm a head of research at the Bonavero Institute and a professor of international law. And it's my pleasure to chair today's discussion. Bonavero Institute of Human Rights publishes reports to provide research-based expert commentary on pressing and timely contemporary human rights issues, hopefully in a straightforward manner. And the aim of these reports is to bridge the worlds of human rights research and human rights practice, and also to make research accessible to wider audiences in practice and policy communities. So the report that we're going to be discussing and launching today is also part of a collaboration between the Bonavero Institute of Human Rights, the Hertie School Center for Fundamental Rights in Berlin, and the Helmut Schmidt University in Hamburg. And this collaboration for the past 2 years has focused on how migration, authoritarianism, and climate change have been framed in European human rights law. But in this very particular report, the aim is to focus attention on how we frame human rights-based remedies in human rights litigation, and how legal victories on climate change cases can or cannot translate into implementation victories. And the report also consciously provides the frame of smart remedies as a way of closing the gap between litigation and implementation in this field. So today I'm joined by a very distinguished panel to discuss and reflect on the report. Our first speaker will be Dr. Marcelo Lozada Gómez. Marcelo is the lead author of this report and holds a Doctor of Philosophy in Law from the University of Oxford. And he currently also works as a climate legal risk consultant in London. He will reflect on some of the key findings of the report. We will then hear a set of reflections, starting with Professor Shifra O'Leary, who is former judge and president of the European Court of Human Rights. And prior to this, she's also worked for almost 2 decades at the Court of Justice of the European Union. She's currently joining us from NYU, where she's a Hauser Global Fellow, and she's also professor and adjunct full professor at University College Dublin, and a visiting professor at the College of Europe in Bruges. And this will be followed by an intervention by Dr. Corinna Harry, and she's assistant professor of constitutional and administrative law at Tilburg University in the Netherlands. Her research focuses on regional and international human rights law and spans the topics of climate litigation, intersectionality, as well as the role of courts. But I must also add, she's also written seminally on climate remedies in human rights litigation cases. And she's the Deputy Director for Europe of the Global Network for Human Rights and the Environment, and regularly provides advice on rights-based climate cases to members of civil society and litigators. And finally, we will hear from Cesar Rodriguez Garavito as our final speaker. Cesar is an Earth's rights scholar and field lawyer, and he also is the founding director of More Than Human Rights Life program at the NYU School of Law. He's a professor of law and director of the Earth's Rights Research and Action Clinic at NYU as well. And his work has advanced some very important ideas, as well as legal and practical actions on a wide range of issues, of course, on climate justice, but also on indigenous rights, and what he currently works on and calls more than human rights, rights of nature. And his recent publications also include a book just recently published by Cambridge University Press, Climate Change on Trial, Mobilizing Human Rights Litigation to Accelerate Climate Action. So this is an incredibly exciting and outstanding panel. And I'm very pleased to first give the floor to Marcelo to make some remarks. Let me just say that after all of these remarks and interventions, there will also be an opportunity for you to ask us questions by using the Q&A button or the chat button or whichever you please, and we will be happy to distribute those questions to the panelists afterwards. So welcome, and over to you, Marcelo.
Thank you very much, Başak, and thank you to everyone for being here, to the participants and to our panelists for accepting our invitation. I will share a couple of slides simply to perhaps provide some illustration on the topics that I will be discussing, which is mainly a summary of the report. Can you see the whole picture now? Perfect. So I have 5 minutes to provide an overview of the main ideas of the report and try to convey the kind of author's idea behind this. So we started with a simple observation around a problem. And that observation was, as Başak mentioned before, that litigation wins or court victories in climate litigation cases do not always lead to effective climate action. So despite this being, in many cases, and in most cases, the main goal of litigation, that is to foster effective action, climate action from governments, but we observed that litigation didn't quite lead to that in many cases. So we ask ourselves, well, what are the barriers creating this gap? Why is this happening? And of course, this is not a new phenomenon. This has been explored in other areas of litigation, such as social and economic rights, and even in other areas of the human rights literature. But we try to start to focus on a specific case of climate litigation and what the drivers were in this case. And then finally, we asked ourselves, what could then be required to bridge this gap? What could be done to address this issue? So we wrote this report with the aim to make 3 main contributions. The first one was to map the remedial landscape, that is to say, to provide an overview of the different climate remedies that were being ordered by courts in rights-based litigation around the world. And we came up with a short typology of 4 types of remedies. So the first one is implementation mandates for existing frameworks. That means courts ordering governments to abide by existing frameworks, to existing regulation or laws. So this could be, for example, the case in the Notre Affaire à tous case in France. The second type was requirements for new targets set in legislation. This means courts asking or ordering the governments to pass new legislation to set new targets. And this has recently been done, for example, in the Do-yoon Kim case in South Korea, but this was also done to some extent in other cases, like the Urgenda case or the Neubauer case in Germany. The third type consists of oversight mechanisms. In these cases, courts come up with mechanisms to oversee the implementation of the remedies and the implementation of public policy around climate change. And this has been most famously done in Asghar Legari, where the court judicially created a climate change committee that then followed up with a series of recommendations and engaged more actively in policy making in Pakistan. And the fourth was procedural requirements. In these cases, courts perhaps order not targets specifically, or do not create institutions to engage in policy making, but rather they order some processes to be had in order to protect rights when designing or implementing climate action. And this, for example, was done in the case of the Workers' Union of Samarco in Chile, where the court ordered the state to decide transition plans, energy transition plans, together with the participation of certain workers being affected by such transition. Secondly, our contribution was to identify some implementation barriers. And here we just We just name a few concerning institutional inertia, resource constraints, capacity constraint, the fact that climate change requires engagement with polycentric governance. Polycentric governance, that means governance are across policy sectors rather than a single one. A third being a more temporal issue, that is, that climate change requires urgent action, but with a forward-looking and long-term vision, and that causes tensions. And finally, some distributional challenges that relate to the fact that climate change can affect multiple policy objectives and can entail trade-offs that are very intricate and therefore require complex policy making. And finally, as Başak mentioned in her introduction, we propose a framework for smart remedies. This is a set of principles that courts can use to navigate the complexities involved and the drivers, the barriers that we identify behind the implementation gap. And here I'll just briefly mention some principles. One is balancing specificity and adaptability. This is something that courts are already doing at different levels. And this means you can perhaps identify clear outcomes consistent with international consensus and scientific evidence, but leaving for the governments to determine what the pathways should be, the specific pathways to achieve certain goals. Secondly, naturally, use best available science to come up with certain remedies, but always allowing for updates and adaptability over the long term. Thirdly, aligning remedies with institutional capacity. This means understanding that remedies should be feasible for implementing bodies in order for them to then lead to effective climate action. And fourthly, and lastly, some accountability and transparency mechanisms that allow for participation, regular reporting, and in particular, civil society oversight, which we believe increases the cost of non-compliance and therefore leads to more effective implementation. With this, I'll end my intervention, and I look forward to listening to our panelists and, of course, what they have to say about these ideas. Thank you.
Thank you. Thank you very much, Marcelo, for outlining these parts of the report. So let me turn to Professor O'Leary for her remarks. Thank you. And you are muted.
Thank you very much, and good morning or good evening to everyone, depending on where you're located. It's a real pleasure to participate on the panel, and my thanks to the authors of the report and also to the Bonavero Institute for including a judicial voice on today's panel. I should stress that the two scholars who are going to address the subject today their work both focuses on climate change law. And when I was a judge at the Court of Human Rights, I, of course, worked on the three groundbreaking cases in which rulings were delivered in April 2024. But human rights-based climate change litigation formed and still forms only a tiny fraction of the docket of that court. In other words, I know the climate change litigation, the subject of the report, very well, but I'm not a climate specialist. And perhaps that's the point. The report is aimed at a number of different stakeholders, but it is firstly aimed at judges when it comes to crafting remedies suitable to the particular nature of climate change cases. And the report's judicial addressees they won't be climate specialists. Most likely they'll be constitutional court judges, judges dealing with ordinary tort cases in which human rights-based climate change arguments are raised, or judges dealing with simple licensing and planning applications, such as those which we saw the subject of the UK Supreme Court decision last year in Finch, or the decision of the Norwegian Supreme Court in Greenpeace Nordic, which of course is the subject of the most recent judgment of the European Court of Human Rights in relation to climate change. In the short time available, I'd like to highlight just 5 points, inspired by the report itself, first-hand experience of cases like Klima Seniorinen, but also inspired by reactions to those rulings, whether the reactions have been political or scholarly. So the first point is the role of courts in climate change litigation. Courts are as essential as they are necessarily limited in their role. And I welcome one aspect of the report, which I think is very clearly stated. I'm referring to page 6, where the report recognises the courts' essential role while acknowledging the complex institutional ecosystems in which judicial mandates must operate. You know, step back and think about it. The separation of powers, respect for democratic processes, and even the nuts and bolts of how courts exercise their competence. In the case of the Strasbourg Court, that means, of course, exhaustion of domestic remedies or the extent of extraterritorial jurisdiction. All of these are highly relevant considerations in relation to what judges do and what they can do. And I think the report very successfully leans into these aspects and it doesn't ignore them. And this is important because the critics of climate change rulings handed down by national and regional courts, they like to ignore the fact that the Belgian Court of Appeal, that case is of course still pending, the German Federal Constitutional Court, or indeed the Strasbourg Court, to name just three, all of those in courts engaged fully and openly with what their complex institutional ecosystems required and allowed. And therefore, I think page 22 of the report, it points to something which I think is crucial. For me, as a judge, it's the key takeaway, which is that courts provide governance catalysts rather than final solutions. And that brings me to academic engagement with what courts in climate change cases do or what they failed to do. When the Klima judgment was handed down, it was initially welcomed as a valuable starting point. And of course, with time, there have been more developed critiques, which are absolutely necessary and welcome. But for example, one critique has criticized the court for its perceived unwillingness to engage with sort of the global inequities of climate change, structural inequalities, race, and intersectionality. And I think it's important when engaging with climate change judgments to understand that they should be critiqued. I'm absolutely fully in favor of that. But you have to look at who are the actual applicants before a given court? What were the legal arguments placed before the court? Because courts cannot do what all commentators would like them to do, because intersectionality, global inequities, these simply weren't issues before the Strasbourg Court in the relevant cases. I say this because at a time when international and regional courts are subject to a lot of criticism, which is often very opportunistic and politically self-serving, I think we'd have to be careful as practitioners, judges, legal commentators, how we engage with climate change litigation. My second point relates to judicial dialogue. In 2022, in his publication, Litigating the Climate Emergency, Professor Garavito and also Corina Herry in her work, Since Klima, they've highlighted the extent and nature of judicial dialogue across jurisdictions, across regions, and across different systems in human rights-based climate cases. And following the rulings of the Strasbourg Court in April 2024, that judicial dialogue, we've seen it's continued implicitly or expressly across the three advisory opinions of ITLOS, the Inter-American Court of Human Rights, and the ICJ. From a judicial perspective, I think what's really useful in this report is that it systematizes climate change decisions to date. I'm, of course, concentrating on the European ones, which I know better. But as you saw from Marcelo's introduction, it really looks at the global climate change litigation. And then from that systematization, it extracts helpful and excessive climate change remedy guidelines, which I think are incredibly useful for judges. And I'm not going to go over the summary which Marcelo just gave us, both of the cases, the type of remedies that you see in those cases being crafted, and then the principles that the report extracts from them. This brings me to my third point, which relates to judicial tailoring and climate change cases. The court reflects what national, regional, and international judicial rulings have showcased to date in terms of the specificities and distinctive nature of climate cases. We know what we're talking about, the unprecedented temporal complexity of these cases, the fact that judges have to assimilate and incorporate scientific evidence which is complex and constantly evolving, and also the polycentric nature of climate change itself. And as you know, these characteristics led the Court of Human Rights in the Klima judgment to look at its environmental case law and to tailor the use of that case law to the specificities of climate change. And in this report, we see similar tailoring of remedies with distinct approaches for mitigation and adaptation cases. Again, this is extremely helpful for those on the ground. also because tailoring really is absolutely vital for climate change cases. Professor Garavito pointed out in his 2022 publication that human rights liability mechanisms tend to look backwards at responsibility for individual rights violations committed in the past. But climate change disputes are different. As evidenced in Urgenda, Neubauer, Klima, to name just 3 cases, they required us to look forward. I think the words of the German Federal Constitutional Court are particularly striking. They referred to fundamental rights as intemporal guarantees of freedom. And I think you see that theme reflected across national, regional, and international judgments in relation to climate change. My 4th point relates to remedies, the Court of Human Rights, and the margin. And I think here probably what I'm about to say won't be welcomed unanimously by everyone, but I think it's important to reflect a little bit the experience on the ground of what the European Court of Human Rights does. Many commentators, and indeed Strasbourg judges, have expressed frustration in the past at the way in which the Strasbourg Court deals with particularly non-pecuniary damages and the sparse use of individual and particularly general measures, instructions or indications given under Article 46 of the Convention. Now, the subject of Strasbourg remedies and frustration is far too vast to deal with in my 10 minutes, so I'll just look at Klima. What did the applicants ask for? What did they get, and why did they get it? Firstly, the applicant association didn't submit a claim for damages, and I think it's fair to say no claim, no damages. Secondly, as regards Article 46, and I'm quoting from a section of the judgment, I think it's paragraph 543, the applicants accepted that given that the choice of means to implement whatever the court's judgment would be was primarily for the respondent state, that's in accordance with the Strasbourg system, the court should not specify the measures to be taken. So I frame this as a question, is it surprising, given the groundbreaking nature of that case, and particularly the differentiated margin of appreciation which the court established in that case for climate change cases, that the court left it to the respondent state under the supervision of the Committee of Ministers to ensure that measures guaranteeing convention compliance were adopted. It is possible to have a much more prescriptive approach to remedies in Article 46. I've read Karina's excellent article in the ECHR Law Review, but again, a question, was that prescriptive approach likely to be accepted by a Grand Chamber in the first climate change case, treading as carefully as that court clearly was trying to tread in that very new and difficult context? There are, of course, consequences for the fact that the court hands down declaratory judgments. The Committee of Ministers has to engage in a technical and interpretative exercise during the supervision process. But as a judge, I would say, it's not that the issue of remedies is too extensive or too complex to address. In certain systems, when there is a margin of appreciation, as is the case in the Strasbourg system, the question is which authority within that system is the appropriate authority to engage in the detail. This brings me to my 5th and final point, which relates to the importance of multi-stakeholder oversight. So I'm moving from the position of a judge before judging and the judgment to what happens after a judgment is handed down. The report highlights that success often depends significantly on the engagement of civil society in monitoring implementation. And let me speak with a few details to some of the lessons that I think civil society and legal practitioners could learn from Klima. The engagement of civil society prior to the 2024 judgments was really significant. The court received, I think the figure is about 37 third-party interventions across all the 3 cases. But if we look at what the court's case law requires during the supervision phase, I'm thinking of judgments like Mammadov and Kavala, which are the 2 infringement judgments where the court was very clear on what Article 46 requires. The court pointed out that declaratory judgments have binding force and that when executing, states, and this would logically mean also the Committee of Ministers, are required to ensure, and I quote, their effective execution in good faith and in a manner compatible with the conclusions and spirit of those judgments. Now, the Committee of Ministers first rejected the Swiss government's action report in March 2025, but in September this year, it welcomed the adoption of what it referred to as a comprehensive legislative and regulatory framework, and it accepted that suitable quantification had taken place at the Swiss end. I'm going to leave it to other members of the panel or the audience to assess whether in September 2025 the Committee of Ministers lived up to its responsibilities as the first intergovernmental body monitoring the climate action of a member state following an international court judgment. In the interim, we have, of course, the advisory opinion of the ICJ, which is very legally significant, although it may not be binding as such. As regards oversight, in Klima, only 3 groups of NGOs and the Swiss National Human Rights Institution made what are known as Rule 9.2 submissions to the Committee of Ministers. And I think in terms of multi-stakeholder oversight, the case of Klima reveals that civil society should not lose interest after a judgment is handed down, because civil society doesn't just provide essential oversight in relation to the respondent state, it also provides essential oversight in relation to the supervision mechanism tasked with ensuring proper execution of court's judgments. I'll conclude by saying that I think the report is accessible, timely, and a really valuable contribution for all those who, willingly or unwillingly, judges don't choose what cases land in their docket, have to be engaged in climate change cases and their aftermath. So my thanks to the authors, and thanks also for organising this interesting panel, which we'll hear more from the other panelists and the audience now.
Thank you. And thank you so much for closely engaging with the report. So for those who are with us, the report is online and it's openly available from the Bonavero Institute's website. So with that, maybe I'll turn to Dr. Harry, Dr. Corina Harry, for her remarks on the report. Thank you.
Thank you so much. I hope you can hear me, and in a second we'll also be able to see my slides. Just a minute, I think. Apologies. I can only see Başak. So Başak, if you could give me a thumbs up if perfect. Thank you so much. Thank you so much for the invitation to be here and to help launch this very timely report. It's also a real honor to speak after former President O'Leary. I think the way that I approach both remedies at the court and climate cases at the court is very different. I'm one of those people who is guilty of always wanting more engagement and more from the court, but I think the result that I get to today is not that different from Judge O'Leary's position. So what I'd like to do today is I'd like to use my 10 minutes to highlight some of the central challenges facing remedies in climate cases. And to do that, I'd like to continue the discussion on the Verein Klimaseniorinnen Schweiz case, the Swiss climate case at the European Court of Human Rights, from both the perspective of the court and of the respondent state. And to do that, I'd like to discuss or eventually discuss what smart remedies might look like in this context and what we can learn from the report in designing those smart remedies. In doing that, I want to push back against the idea that climate change and climate change related human rights impacts might be too big to remedy, might not be possible to remedy through judicial proceedings. So in other words, I'll be zooming in on the Klimaseniorinnen case, but before I do that, I'd like to first zoom out a little bit. I'd like to zoom out for just a second and show you this screenshot, which comes from a database of rights-based climate cases that we put together at the Climate Rights and Remedies Project at the University of Zurich. And as you can see, this covers cases, rights-based climate cases from essentially all around the world. Some of these cases are decided, some are pending, some are domestic and some are international, some are on mitigation and some are on adaptation. And they also vary in the sense that they don't all succeed, whatever our definition of success might be. Where they do succeed, where these cases are successful, one of the main challenges they face is the challenge of remedies and effective implementation, which the report we're launching today, we're helping to launch today, addresses. And of course, I should also say, every one of these institutions has its own different remedial powers, its own institutional situation and capacities. And some are very innovative. So not to indicate that the European Court of Human Rights is per se the most innovative court in this regard. If we, for example, draw a comparison to the Inter-American Court of Human Rights, we see that it has a track record of tailored remedies for collective human rights violations, for example, through community funds that goes beyond what we've seen from the European Court so far. In other words, there's a lot of room for cross-regime learning and judicial dialogue. But like I said, I'd like to zoom in specifically on the Klima Signorinen case to pick up on that some more. And that's not just because we're lucky enough, of course, to have the presiding judge, the presiding former president of the court here with us, but it's also because this case was groundbreaking, it was innovative when it was issued and still is. This was the first time that an international court held a state responsible for violating human rights in a mitigation case. And that makes it a very visible, very high profile example that's also very enlightening when we look at implementation challenges and designing smart remedies. Now, technically speaking, the Klima Signorinen judgment, as we heard, didn't have too much to say on remedies. It didn't order a specific emissions reduction target for Switzerland to meet. It also didn't order compensation for damages for the reasons we heard, aside from costs and expenses. But even so, this case does have a lot to offer, remedially speaking. And that's not only because the distinction between the merits and the remedial aspects are sometimes a bit fuzzy, not specifically in this case, but in a general sense. And so on the merits, for example, Klima Signorinen did recognize that Switzerland had a regulatory obligation to mitigate the effects of climate change. And it also took a differentiated approach to that margin of appreciation that we heard about, limiting state discretion in how to implement those obligations. And these are things that are highlighted in the report as well as part of a remedial framework. But then secondly, and importantly, I'm particularly interested in the fact that the story of this case didn't end with the 2024 judgment. We're still in that implementation monitoring process that we heard about. And so far, there have been those two documents from the Committee of Ministers that have evaluated Switzerland's implementation of the court's findings. And this process shows several things. It shows that a single case like Klima Signorinen can lend itself to a variety of remedies along the lines of the typology of remedies that was created by the report and that was explained by Marcelo. That's because the Committee of Ministers didn't just discuss regulating targets and setting carbon budgets. It also, for example, invited Switzerland to set up an independent national body to monitor its climate policy. And on access to procedures, we've seen it continue to monitor the response in and around the domestic courts in Switzerland. And in doing so, it's received a large amount of input from NGOs and also updated scientific evidence. Now, my reading of the input of NGOs and the fact that it was limited in this process is slightly different. So my reading of this is that there was a large amount of coordination that happened with the NGOs that were participating in this process, and that they sought not to contradict each other and not to overwhelm the court with many different submissions, but coordinated their key positions, and we see that an extraordinary amount of NGOs signed on to some of these submissions made in these proceedings. But in any case, what this shows us is that remedies can be many-layered. They should be understood along a longer temporal axis beyond an individual judgment, and they depend on the collaboration of different actors. And on that note, I'd like to say a few things about the Swiss domestic level. Now, it's only fair to say that the domestic responses to this case were mixed. There was pushback against this judgment from certain corners of the Swiss political landscape. Some actors welcomed the judgment, but others did not. Some alleged rights inflationism or overreach. But that did not stand in the way, or has not stood in the way, of there being legislative changes made in this context. So here on the slide, you see several pieces of legislation that have been either adopted or updated since the Klimaseniorin judgment. And the government's position in this case is that because of this legislation, it has complied with the Klimaseniorin judgment and no additional action is necessary. Now, this is a highly contested issue, and we've seen the brand new Swiss National Human Rights Institution taking a very prominent role in this context and pushing for more ambitious and more science-based targets and budgets from the government. They've argued the Swiss response is not globally equitable, is not compatible with the 1.5-degree warming target in the Paris Agreement. And that just goes to show that the implementation of this judgment is giving rise to some very divisive domestic debates. There's also quite a ways to go in domestic practice. So there has been a follow-up case to Klimaseniorin filed with the Swiss administration. And the Swiss administration, in this case that was brought on behalf of a group of farmers and representative associations, applied the same standards that it had applied before the Klimaseniorin judgment. So did not update its approach in response to the judgment. Now, this is pending before the Federal Administrative Court, and we'll have to wait and see what the domestic courts decide, how they respond to this, but also on the domestic practice, there is some room to go. Now, from an academic perspective, I can't help but always wish for more from judicial engagements with climate change and with climate remedies. But what a deep dive into Klimaseniorin shows us is that it highlights and confirms the approach of the report that we're here to celebrate and to launch. It's clear that staged implementation, so multi-phase implementation, is not only a reality as we see in Klimaseniorin, but also a necessity. Because after all, individual rulings can deliver successes, but implementation remains a long-term and evolving question. It also means that ideally remedies are specific enough to be both enforceable and adaptable to changing science and changing conditions. Klimaseniorin also demonstrates the risk that remedial vagueness can hamper impact if it leads to protracted discussions about what courts actually wanted, actually ordered. And that also allows actors who oppose a judgment to replace the court's findings with their own interpretations. And in that regard, I think the report's gold standard approach of establishing clear, equitable targets is particularly confirmed. And Klimaseniorin also shows how accountability and transparency support implementation. So based, for example, on the Swiss National Human Rights Institution, which has used the monitoring process as a platform to develop its own position and demand more ambitious Swiss action. But perhaps most importantly, what Klimaseniorin shows us is that government discretion can be maintained alongside regulatory obligations, which we see in the way that this judgment both maintained room for the government to exercise discretion in choosing the means and methods of responding to the judgment, while at the same time narrowing the state's margin of appreciation for the targets and objectives to be adopted. Now, I think there's a lot of things we could still talk about. For example, the things that haven't been covered yet by this litigation. So we haven't yet seen interstate claims. We haven't yet seen from the European Court compensation for climate-related damages. And I think there's a lot more to come when we're talking about climate-related remedies. I believe that this report provides a very useful framework for continuing to think about these topics. And on that note, I will end, and thank you very much for your attention and your time. Thank you so much.
Thank you. Thank you very, very much, Corinna, for this very insightful presentation, and also the deep dive and looking at the deep dive and what the what the lessons that are relevant, or we may be able to keep learning by looking at these deep case studies as well. As some of you may have looked at the report, we review around 15 cases from across the world in getting these experiences, and of course, Verein Klima is one of them. But this deep dive has been absolutely fantastic. So thank you. So Cesar, for the last intervention, over to you.
Thanks, Başak. Thanks, Marcelo, and everyone for the opportunity to comment on this really timely report. So I'm going to do three things in the next 10 minutes or so. First, I'm going to speak to what I see as the contribution of the report to the growing literature on climate litigation, specifically rights-based climate litigation, and with an emphasis, of course, on remedies. Then I'll kind of zoom out and try to look at the universe of cases, because as much as clima engineering is important, of course, and I've learned a lot in the last half an hour or so, there are around 500 cases of this sort around the world, and actually, since the database that my recent book is based on overviews the whole gamut of cases around the world, I'm going to try to offer something by way of pointers in which, and this is the third part, the section on smart remedies speaks to that universe of cases and how it helps systematize and point in interesting directions the doctrines and the case law that's been developed around the world over the last couple of decades. So in terms of the contributions, it is the case that some prior contributions to the literature had looked into remedies, but the more recent emphasis on the granularity of the design of the remedies and how they speak to the uniqueness of climate change is something that newer in the literature. And I think that this report really makes a key contribution to that growing interest in remedies, which, as Judge O'Leary said, is something that judges care deeply about, but also that can speak to practitioners, to litigants who, in the end, want those victories or those results to make a difference on the ground. So no one wants a positive ruling, a favorable ruling that is impossible to implement. So this is a key contribution to that conversation. Specifically, I think that the engagement with the temporal dynamics of climate change and how judges here are confronted with a particularly challenging problem, because this is a moving target. How climate change evolves is anyone's guess. Of course, we have very robust science, and the invitation, and this is the second contribution, the invitation to continually update remedies and monitoring processes in light of emerging science is something very welcome in this report. But there's also climate politics, and there is also the potential arrival of tipping points. So this is something that is unique to climate change, the temporality of climate change that the report takes into account. And finally, the report also takes into account the realities of institutional capacity that differ across the world. There are also different levels of institutional willingness. So capacity is one thing, willingness to use that capacity is another thing, and that is, of course, the realm of politics and policy. But acknowledgement of different levels and types of institutional capacity is very welcome. One common institutional capacity that I would make at the outset is that institutional capacity should be seen as dynamic. The report doesn't deny this, but suggests that institutional capacity is a factor of the type of state that we're dealing with. Global South states have limited capacity, whereas Global North states have somehow greater capacity. One of the potential contributions of judicial interventions in climate change and human rights cases is that they can unblock policy processes. They can end or help mitigate bureaucratic stalemates where one agency is pulling in one direction, another agency is pulling in another direction. So state capacity can be created in the context of monitoring the implementation of a given ruling. That is something that I've observed in past work on socioeconomic rights, and sometimes the state officials that I would interview in different countries would say that they had welcomed the court's intervention because it helped them negotiate internally how to move forward, kind of how to push forward a top-heavy bureaucracy in the direction of the protection of rights, of the rights at stake. Then let me move on to the second component of my comments, and I'll share my screen here if I'm able. Here, I think. Can you see my screen here?
Yes,
can you see
if you could maximize it, maybe that will be easier.
Yeah, there.
Yeah, fantastic. Yeah.
Yeah. This is where I want to land, but this is the book that Başak mentioned, and which is the basis, the empirical basis of what I'm going to say. And this is the one that overviews the universe of around 500 cases of this sort. Now, what's interesting in this report also is that it is indirectly engaging with a broader field and of studies and broader literature that Başak, of course, has contributed to, which comes from other subfields of human rights research, like socioeconomic rights. There's a lot of, there's very interesting insights emerging from a couple of decades of socioeconomic rights research that, again, Başak is very familiar with because she's contributed to it. And at the outset, when I first started working on climate change, I was kind of dismayed to see that the specialists in climate litigation, who initially came mostly from environmental law, would not necessarily be familiar with that background of contributions to implementation of socioeconomic rights rulings. This report, of course, solves that gap by fully drawing on that tradition of analysis of socioeconomic rights literature. And the parallel is important, and I'm going to use here, this is what I'm using here, categories of work that I've done and others have done with regard to socioeconomic rights rulings. What they have in common with climate change is a number of things. One, both socioeconomic rights and climate change and human rights cases are trying to deal with the structural issues of state compliance or lack of compliance with major policy challenges, be it access to food or mitigation policies or adaptation policies. Then they usually also both entail budgetary considerations, so expenditures, which adds to the complication and to the contention around these cases. And finally, and importantly, and this is where I'm going to focus the rest of my comments here, they invite complex remedies that need, as Corina said, to last for a number of years, because these are cases, these are situations that cannot be solved overnight. And so if a country is to come up with a higher mitigation target, or if it is to put in place an adaptation policy that is respectful of human rights, that all takes time. Like in Ligari, for example, it's taken already 10 years almost for the Pakistani government to put in place the type of adaptation policy framework that the court called for in 2016. And so these are structural similarities between what we know about socioeconomic rights jurisprudence and what we're finding out now with regard to climate change rulings. I'm going to endorse, and I don't have time to go into details, but I'm going to endorse the framework of smart remedies that is offered in the report, including the important component about multi-stakeholder engagement, and what Judge O'Leary referred to earlier about the courts being a catalyst for a dialogue and an ongoing adaptive implementation of the rulings. I'm going to end just by offering kind of an analytical framework that might help us in the future understand future cases by deploying the typology that the report offers. So the report focuses on the middle bullet point here of remedies. In climate litigation, especially after the ICJ AOs, we're in a very interesting situation where there are very strong rights. And so I'm using Mark Tushnet's terminology of strong court or soft courts, and he distinguishes between the content of the rights, how strongly a given court asserts the content of a given right, say a right to climate mitigation or a right to a healthy environment that leads to expectations regarding to climate litigation, climate mitigation, and climate adaptation. And that is analytically distinct from the question that we're concerned with today, which is remedies. But I want to offer, and this is from past work, that one needs to distinguish also what happens after the remedies are laid out, because different courts are more or less willing to continue to be involved in the monitoring of the implementation of those remedies. So this is kind of implied in the report, but I think that this is so important that it merits kind of a specific attention. And I'm going to end just by adding to the framework of the report this combination that in work I did on socioeconomic rights proved to be quite helpful in understanding which courts made more of a difference when it came to contributing to the implementation of socioeconomic rights. I think that we're now in a situation where litigants and courts have pretty strong doctrines that they can draw on, again, especially after the ICJ's AO that came out with very strong statements of rights, much stronger than anyone would have hoped or feared, depending on where you stand on these issues. And the question is, should courts then couple that with strong remedies? Meaning, strong remedies here means very detailed orders, for example, of the type that would mandate a state to reach a certain level of emission cuts by a certain date, and also dictated the means through which that mitigation target should be attained. Some courts in other fields of human rights litigation, like socioeconomic rights, have gone very far in dictating the details of policy. For example, in prison overcrowding cases, some courts in different parts of the world have set very specific targets and very specific timelines. I think that the report is wise in taking a more intermediate approach and say, in my terminology, the report endorses what can be called moderate approach to remedies, right? Not sitting back passively and waiting for the government to do as they wish, but also being careful not to overly kind of determine the details of policy. By adding monitoring, I think that this typology can help us both understand what happens after the ruling is handed down, and for litigants to push for strong monitoring, which in my experience and in the cases that I've studied is crucial. So I'll give you one example in closing. The Brazilian court in the climate fund case, which famously framed the Paris Agreement as a human rights treaty and as a human rights agreement, and mandated the government to spend the money that had been set aside with international cooperation funds to counter deforestation in the Amazon. the court was very strong on the content of rights, when as far as to say for the first time in any apex court to say that the Paris Agreement was a human rights agreement. Then it was relatively moderate in terms of the remedies, because it just said you have to spend the money. But then, and like what the Brazilian Supreme Court has done in other cases, it remains silent on monitoring. So no one knows really what is in the end going to happen, or the court will not know. It trusts the mechanisms that exist in the legal framework to do the monitoring and to do the implementation. I think that there's room for at least civil society actors and for litigants to push for the type of multi-stakeholder, longer-term monitoring and engagement that the report offers to maximizes the chance that the impact, and this is the last column here, is as high as possible in the direction of either mitigating climate change or adapting to it, depending on the nature of the case at hand. Thank you.
Thank you. Thank you very much, Cesar, for that intervention. We're very happy to take questions from those who've joined us on this discussion. You can write your questions in the Q&A box, and I think there's already one question, and you can also use the chat function as well. I will be able to monitor either of these, and I think we have about 5-6 minutes for this segment. But I just want to first thank all our speakers, because what I'm hearing is different, an endorsement of some of the ideas that we have boxed in around the smart remedies that have come out in the various discussions.